Elville webinar series. It's Friday, October 10th, and our topic is trustee selection and how to choose the right one for you. And there's no one better to take us through this discussion than our president, CEO, managing principal and lead attorney, Stephen Elville. How you doing today, Steve?
Good morning, Jeff. Thank you for this beautiful weather. How are you?
My pleasure. Do you have any more titles that I can add to your name?
Oh, no. Now you're going to make me embarrassed. But I
No.
was going to ask you, Jeff, I see that the leaves are changing outside. I was going to ask you, what are you going to dress up for Halloween? Do you know yet?
I was thinking of Fester from the show Wednesday as part of the Addams family. So.
Oh, okay. Well, all right.
A little bit already, so.
We won't go there, I guess. All right.
Go through housekeeping items. We encourage your general questions today. Please note them in the questions panel, and we'll pause periodically. And yesterday by email, you received the presentation slides as well that Steve's going to be referencing. They're also available in the section marked handouts on your screen to download at this time. Right after the presentation, so please take just a couple minutes to develop this really simple but very important survey to offer us your feedback. And welcome to our advisor community as well. 1.5 continuing education hours are available for most everyone that attends today. So please send me your accreditation and ID number so I can submit your hours for approval and also send certificates out. And a question for you: have you achieved your planning goals, or have those goals shifted since you last looked at your planning maybe a few years ago or even 20 years ago? Here at Elville & Associates, we're a leading resource for your family's planning needs, whatever it may be. If you're starting from scratch, if you're revisiting old documents, if you have an estate administration matter to attend to, Steve and his team are happy to counsel you and provide guidance throughout the whole process. So we'll move through a brief intro and then we'll jump right in. Okay, just making sure that everybody's on here. It looks like we are. Okay. So Elville & Associates, founded in 2010 in Columbia by Stephen Elville.
Jeff, I think you're having some audio issues. I'm sorry to interrupt you there, Jeff. I think you might be having some computer audio issues, so just be aware of it. You're cutting in and out, and apologies to all of the listeners.
Yeah. Let's just take a second here. Can everybody confirm that they are able to see my screen and hear me at this time?
You're slow a bit and also a bit garbled. So I don't know if you need to rejoin the meeting or if you even do that, Jeff.
Yeah, I think that'd be a dangerous thing to do here. Let's see. Hi, everyone. Could you confirm that you're on the presentation by noting something in the chat section, please, or the question section?
And Jeff, please let me know if I'm slow as well.
You are fine.
Okay.
I'm not getting any response from anybody in the chat or the question, Steve. I'm concerned that you and I may be the only people on the presentation here, even though it says we have several attendees. Okay, there we go. Okay, let's move forward then. Looks like we have some people saying all good on their end. So.
Very good, thank you.
All right. So, as I mentioned, many different practice areas here at the firm. Our mission has always been the same at Elville & Associates, and that's to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot at Elville & Associates. We do it in several different ways through our planning processes with our clients, and we have different programs to suit all families and individuals through our educational webinars and workshops in the communities that we serve each year. We also have our annual client event coming up on October 18th, next Saturday. Looking forward to that. I hope you're going to be there. And also by way of our accredited client care program, we're one of only 2 firms in Maryland to have a client care program accredited through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. And just a bit about Steve. His work as an attorney for many years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of many different national professional organizations, and peer groups, Steve works to offer peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve's a very seasoned speaker, if you haven't heard him present before, offering many webinars, workshops, presenting at conferences, and continuing education events each year. And Steve was named to the Maryland Super Lawyers list for a 10th time and 9th consecutive year in 2025. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charity that Steve founded in 2014. I'm very fortunate to be a part of. If I were to flip my camera around right now, I'd show you about 15 guitars and about 30 other instruments that we're going to be getting out to the community here in the next few weeks. And very proud of the work that we do here, making a musical difference in the lives of children each day. If you want to learn more, please reach out to me. I would love to share our great story with you. For now, Steve, I'm going to turn everything over to you and make you the presenter.
Thank you, Jeff. I saw you playing that concert bass back there.
That is quite a bass. Sorry for the bit of a jumbled start here, everybody, but I think we're on track and ready for a good presentation.
Thank you, Jeff. I am now going to get my screen up and go to my desktop where I have the presentation. And I thank everyone for being here. I'm getting ready to start my slideshow. And I say to myself this morning how beautiful it is outside, how lucky I am to be able to be here with you this morning on a Friday morning. Halloween is coming up, fall's coming up, our client event is coming up, and many of you have questions and concerns, and that's why you're spending your time here this morning with us. Jeff, thank you for everything you do. And for those of you on our webinar for the first time, or you may not be aware of this, Jeff and I have done hundreds, if not thousands, of webinars and other presentations together over the years. And Jeff is our community relations director and the executive director of our charity. And I can't thank Jeff enough, and all the people who work at our firm, attorneys and staff. And I'm privileged to lead that organization and all of our collaborative partners, and you making our webinar series possible by attending today. So thanks to everybody. All right. We're going to now set the stage for learning, and what we're teaching today is trustee selection and how to choose the right one. Now, obviously, that is the key today of our presentation, but there's a lot of different aspects to that, and I'll just step back and tell you something that you probably already know, and that is that nothing could be more important, in my opinion, in 2025 with regard to estate planning and trusts is who is going to be the fiduciary, who is going to be the trustee, the successor trustee. Are those trustees going to be individuals or let's say a corporate trustee? How do we know which ones to choose? Well, a lot of it has to do with where you are right now, okay? You may be in a certain place in life or a certain place in reference to your own planning, or maybe you are a trustee. So I'm just going to go down a brief list. For example, you may be here today strictly because of the subject matter. I want to learn how to select trustees and how to think about it. So that's the main thrust, right, of the presentation. But you may also be a trustee now. You may have found yourself in a fiduciary position to serve as trustee, and you want to learn more about your responsibilities. Well, we are here to help you, just to let you know that there are resources available. We are here to help you to, meld in the fine points, fill in the fine points, and learn how to fulfill your fiduciary duty. Because in 2025, you do need to know how to do that, because beneficiaries are entitled to certain notices and information. We're going to talk about that. Or you may be someone who is designated to serve as a trustee in the future. So maybe you're just here to try to get your feet wet in this subject matter. Or maybe you are someone who is the beneficiary of a trust and you're dealing with a trustee already, a person who is a trustee for you, for your benefit in a trust situation. Or you may be a person who is considering changing trustees. Maybe you have a current estate plan and you are considering transitioning to new trustees. So whatever your reason for being here this morning, we want to provide value. We know that your time is valuable, And we're going to begin on time as we did, and we're going to end on time. So I'm going to now move through the subject matter. Remember, this is not an attorney-client relationship situation. This is just high-level legal education for the general public, for our collaborative partners, and for our clients, client families. This is not a legal relationship, but we can establish an attorney-client relationship if you would like. So as we try to lay a very large groundwork for the discussion, let's talk about today, what is a trustee and what are their responsibilities, wherever it is that you may be in the process of thinking about trustees. What are the types of trustees? I just alluded to a couple of different types and the advantages and disadvantages. Then we're going to talk about what is the quote perfect trustee, and let's set some benchmarks for your thinking. How can I think about this? What is the frame of reference? Then we're going to talk about generally, why trustee selection is so important, okay? And what is important about it in a changing world. We're also going to talk about trustee succession, okay? And why is that such a big deal, right? Because we do the very best we can during our lives to articulate what our intentions are, but how do we think in terms of succession? And then I'm going to give you a general framework of how trustee roles actually are fulfilled in wills and trusts. And remember, trusts come in different varieties. We're going to focus today on the revocable trust versus another focus, which will be trusts that are established at death. And then why are some reasons you should consider appointing a quote corporate fiduciary? And then why are you probably to be concerned about successor trustee risk? So what is a trustee and what are their responsibilities? Well, throughout the common law and now into the modern era, it is possible to leave assets in trust. Now, we just talked about a revocable trust, and I may be redundant this morning in my discussion about these things, just for your benefit. So I may repeat myself with apologies. But let's talk about a revocable trust, which is nothing more than a substitute for a will, okay? Trustees are going to have certain responsibilities. Then there are irrevocable trusts where trustees have responsibilities, and those trusts can be created during lifetime. We call those inter vivos trusts, lifetime trusts, or those trusts could be testamentary. They could be trusts that are established at death. So just making sure that we're fully aware, this is a broad subject matter. We're going to try to take away some substantive issues, but keep these things in mind. And if you have an old-fashioned pad of paper, you have a tablet, you have whatever device you have to be able to make notes, I encourage you to feel free to draw a few circles. Those of you who know me know I love to work from the whiteboard and to illustrate estate plans and flow charts and so forth. So I want you to think in terms of simple trust, like a revocable trust, versus a testamentary trust at death, or a trust that's created during life, like a life insurance trust or a charitable trust. What are trustees and what are their responsibilities? Well, a trustee is supposed to, quote, administer the trust, of course, follow its terms and provisions, keep accurate records. This is an important thing. Be accountable to the beneficiaries, right? Make distributions according to the terms of the trust. Now, you'll notice here in that bullet point, mandatory or discretionary distribution. So what does that tell us just here in the first 3 or 4 or 5 bullet points here about the role of a trustee? There are different types of trusts. So the purpose of the trust, the purpose and reasons for the trust, the intentions of the trust are going to, in a way, shape the responsibilities of the trustee. But of course, in the terms and provisions of the trust, the trustee is going to have certain discretionary or mandatory activities that they are supposed to be responsible for. Trustees are to make trust investments. Now, let's think about this. If you are a trustee of a trust, especially an irrevocable trust at someone's death or an irrevocable trust during life, you have a fiduciary responsibility to make sure that assets are appropriately invested. So you need to make sure that when you invest those assets with a professional, that you have an investment policy statement and other things that send a signal to you and to the world that you are fulfilling your fiduciary responsibility according to the purpose of the trust. This could have to do with the age of the beneficiaries and so forth. Communication with the beneficiaries, very important. In some cases, not just communication, but advocacy. Ensuring that all tax filings are complete. Do trusts have their own tax filing requirements? The answer is a big yes, and you need to know about that. You don't have to be a professional in being able to create these filings, but you do need to engage professionals to handle it. And then along the lines of trust taxation, manage the assets accordingly. You need to understand certain concepts. So these things are the role of trustees. Now let's review some definitions and basics. A trust is a relationship. It springs from an agreement between a grantor, the person who's creating the trust. Now let's stop right there. Many of you have been around and you may remember a time when this was a different terminology, a donor or a trustor instead of a grantor. Well, that terminology is all the same. The grantor is the modern term for a person who creates a trust. And then the trustee is going to be the person who is entrusted to carry out the intent of the trust. So the parameters and roles of the responsibility of a trustee are prescribed within the trust. Now, how many of you know someone who is a trustee or maybe could be a trustee or maybe has served as a trustee and they never read the trust? It shouldn't surprise you, and it probably won't, that many trustees serve as trustees of a trust that they maybe have perused once or maybe never even have read at all and really don't understand the terms and provisions of the trust. So just remember, understanding the parameters of the trust, what is prescribed within the trust and the applicable law, that is a fiduciary responsibility. And we're going to talk about this later, but why am I so concerned about this fiduciary responsibility? Well, not only is it important for the beneficiaries of the trust, but it's important for the trustee of the trust, because what can happen if you don't fulfill your fiduciary responsibility? You can be removed as a trustee. And what could be more painful? What could be more embarrassing than being removed by beneficiaries who are not necessarily disgruntled beneficiaries, but these beneficiaries say that you have not fulfilled your fiduciary responsibility. So it's not only an important thing, generally speaking, under the law, it's personal, and we have to take it seriously about what the fiduciary responsibility of a trustee is. So we'll be intentionally redundant, as Jeff often accuses me of being, and go down to the second set of bullet points here. So a grantor or a settlor or a trustor in the old days is the person establishing the trust. The trustee, who is an individual or a corporation, and we're going to learn that that individual person could be an interested trustee by relationship, or it could be an independent trustee, is the person who accepts the property placed in trust and puts that property forth for administration inside of the trust for the benefit of the beneficiary. And of course, I'm talking to you here at a 4th or 5th grade level intentionally. The beneficiary is the person or persons for whom the trust property is intended, okay? And it's supposed to be for their benefit. Now, of course, this could be a charitable beneficiary as well. So I'm talking very broadly here in terms of person or persons in the trust. As I mentioned earlier, revocable trusts are basically substitutes for wills. They can be amended, modified, or revoked by the grantor. Many of you on this webinar have revocable trusts. And remember that the income, the taxable income of a trust that's revocable, is passed on directly to the grantor. And we're going to find out in a moment that this is a grantor trust. This gets attorneys all mixed up. It gets lay people all mixed up. But a grantor trust is a trust where the grantor pays the tax. Now, an irrevocable trust generally may not be amended. Now, let's stop there for a minute. Some of you have not heard this concept and you may be shocked, but remember that an irrevocable trust in the old days really could not be amended very much unless it was via court. But now an irrevocable trust in 2025 can be amended in several different ways. So irrevocable trusts, as we're going to talk about at the client event coming up, are not necessarily forever. They are pliable. They can be amended in certain ways. But generally speaking, an irrevocable trust is a trust with a special purpose or a trust at death. And these are going to be taxed as what is called non-grantor trust. They're going to pay their own tax. So these are trust basics. We're not going to get too much further into the weeds, but we will be a bit redundant to drive this issue home. So let's talk about some common trusts. Now, we do a webinar here at Elville & Associates about the irrevocable trusts that are being used in 2025, 2026, and there are at least 20 to 25 trusts we go over. We're not going to do all that here, but let's talk about some of the most common basic trusts. So we talked about revocable trusts. What is the purpose of a revocable trust? As you try to get your minds around, do I have enough information to be able to think about trustees clearly? That's really where we're going with this. We're taking a bit of a digression here. But a revocable trust is nice for property management, avoidance of probate. For those of you who have out-of-state properties in South Carolina, Delaware, Florida, wherever it may be, West Virginia, we can avoid ancillary probate by using a revocable trust for a second home. It can provide privacy. It doesn't really provide any asset protection. It doesn't provide any tax savings, but it can save on administration expenses after our passing. So it's a little bit more to set up a revocable trust, is a little bit more of a process, but in the end, the revocable trust can provide some significant benefits. Now, there are trusts for at-risk beneficiaries, people that have special needs, people that should not be managing their own money, people that are minors, people that are adults with substance abuse issues or other life issues. So the trustee holds the property and uses this for the best interest of the beneficiary. These trusts can be temporary in nature, or they can be long-term trusts, what we might call dynasty type trusts or bloodline trusts. And for those of you who think that the dynasty trust concept or the bloodline trust forever trust concept is only for super wealthy individuals, that is not true. You can use these concepts to protect beneficiaries, and there are other ancillary benefits, such as keeping property in those trusts from ever being estate taxed again throughout the years, and other benefits. You can establish trusts for beneficiaries that they have some control over. Beneficiaries can have trusts where they are the trustees of their own trusts, and there are pros and cons to that. And there needs to be certain flexibilities in the event of a lawsuit or a divorce. However, when we are protecting beneficiaries in trusts through, these are not revocable trusts now, these are irrevocable trusts at death, or these are trusts that are established during life that are irrevocable for the benefit of a certain beneficiary. There are exception creditors, such as Uncle Sam, such as alimony and child support obligations. So except in the state of Nevada, where I understand there are no exception creditors, the general asset protection trusts that can be established through Maryland law, we're still going to have those 3 exception creditors, but these types of trusts protect generally. Then there are people with special needs or people with disabilities, people with chronic illnesses that have to have their public benefits or for other reasons have to have a supplemental or special needs trusts. These are third-party trusts, or the special needs trust type is the self-settled special needs trust. And the purpose of these trusts, again, is generally to perpetuate the public benefits or the means-tested benefits of someone. And if you are the trustee or you're contemplating who the trustee should be of these trusts, we want to think in terms of individuals or sometimes family members, sometimes not, and how the trustees are structured If we are naming a corporate fiduciary, we cannot be assured that they will actually administer a special needs or supplemental needs trust. So many corporate related fiduciaries will not serve as trustees of these types of trusts. And then we have to think in terms of, well, if we're not going that direction with a corporate trustee, is the family member the appropriate trustee, or is a non-family member the best trustee, with a family member instead being an advocate instead of a trustee? So these are the types of things that we're just going to be wrestling with when we sit in the conference room, when we're sitting counseling, when we're sitting in partnership, trying to figure out what is the best approach for the future. And I will take another brief digression, because this brings up the issue of maintenance and updating. So again, we're going a little bit around the world here to think in terms of, how do we think about trustees? How do we think about trusts? What are the foundational concepts that will help me think about trustee selection? Well, again, what you're seeing here is I'm giving you some background information. But once you think about your trustee selection, remember, generally speaking, you are not locked in forever. You can use memorandums of intent to show your intention for your trustee that you select. Throughout your lifetime, people are living much longer lives than used to be the case. You will probably have a second or third chance, maybe even a fourth chance, to change your planning and continue to update your trustee selection. So a good thing to remember is, I'm going to do the very best I can with this trustee selection idea, but I'm going to give myself permission to change trustees in the future, maintain and update my planning in the future to continue to revisit these issues. So again, being intentionally redundant, the trustee is the person who accepts the property that is placed in the trust after a grantor has established the trust and given direction about the terms and provisions. The beneficiary is the person who the property is intended to benefit. Now, I'm going to go over this, and then we'll take just a moment to see if there are any questions. Grantor versus non-grantor trust. So I'm going to use my hands. Let's say this was a revocable trust. This is a substitute for a will. That's a grantor trust. So what does the grantor have to do? The grantor has to understand that they will pay their own income tax on their own 1040. Nothing has changed. Now, you'll notice I'm going to keep this particular hand up. Let's say this was a different type of grantor trust. You were establishing a life insurance trust, okay? You were establishing a gifting trust, a trust where you were going to make gifts for children or grandchildren. You were establishing what appears to be a very complicated trust, a spousal lifetime access trust, a SLAT it's called. So now all of those trusts that I just mentioned, and there are others, are grantor trusts. Even though they're more complex trusts and you're thinking about who the trustee should be of those trusts, the trust grantor, meaning you or the person who created that trust, is the person that pays the tax. Now I'm going to hold up my other hand. Now let's talk about non-grantor trust. A non-grantor trust is a trust like a trust at death, a trust that is established after we die. That trust is going to pay its own tax. That trust is going to file a Form 1041 every year. So that's a different situation, and you need to understand some basic concepts about that. How does that trust work with regard to taxation, which is above and beyond today's discussion? And what is my trustee's obligation every year to understand and manage the taxation of that trust? So as you think about trustees, just remember, a trustee needs to be a person who obviously is a go-to person, a high-level person, a person that you would feel good about, fiduciary duty and handling that. But it needs to be a person who understands, I'm going to hire professionals who are going to help me understand how to fulfill my duty with regard to tax filing and understanding the difference between grantor and non-grantor trusts. Jeff, I'm going to stop just a second. We've been going for about 25 minutes. I just want to see if we're good technically and whether anybody has any questions.
Well, thanks, Steve. We do have a question. Good question. After having discussed with my 3 sons, one of them agreed to be my trustee and executor of my will. Now he says he does not want to take that responsibility. My other sons are not as law aware. What are my choices?
Well, thank you for that wonderful question. I'm sorry to hear that because I know that kind of puts you into a quandary there. So I think the positive part of that is your son is saying, hey, I just don't think I'm going to do this. So it's actually good that he did that. So let's say that you have these other 2 sons. Well, I guess one choice would be you could make those sons co-trustees. Okay, so they would both act together. Maybe that would equal a stronger whole. I don't know. You could name both sons with another outside trustee and have 3 co-trustees. Sometimes that's not such a great idea, but you could have this independent person serving, but you're not excluding your other sons, and there may be pros and cons to doing that. You could simply use another outside trustee, and this could be an interested person, someone who's related to your sons, that your sons respect, but they are an interested person, and maybe you feel okay about that, maybe you don't. This could be a relative of yours, or potentially you would use an independent person. So it doesn't have to be a bank or a trust company. You could use a friend of yours who's an independent person. Well, that is going to give your sons, especially if they were receiving further trusts, that's going to give your sons better asset protection. But let's get more fundamental. Let's just talk about the general administration of your trust or estate. That friend or independent person that you just happen to know, that person would be entitled to compensation, and maybe that would be a good solution. Another idea is to look to your broker dealer and say, who is a trust company that they are affiliated with, and would that broker dealer's trust company or related trust company relationship, would they be willing to serve and serve as my executor or personal representative and my trustee? Another choice is attorneys. We serve as trustee, for example, here at Elville and Associates through our Waypoint Fiduciary Services. CPAs will certainly many times serve. So there's lots of ways to get at this. You also could do this without alienating your 2 sons if they are not going to be appointed. And it could be a positive thing that you have, come into the notion that the information that this is just not going to work. So I'll encourage you that if you will kind of work through this, you're going to have epiphanies about how to work through this. So the good news is your sons are entitled to information and notice, even if they are not serving as trustees. And I guess lastly, if your 2 sons are appointed as trustees and maybe co-trustees, you can advise them that they have to consult with attorneys or other advisors, and that might get you over the hump.
Steve, thanks very much. One more question, a little bit different. Can you please define a life estate deed and the advantages or disadvantages of including this in an estate plan?
Well, thank you for that question. It's a little bit off of our subject matter, so I'll just be brief but I appreciate your question there. So a life estate deed is where you can say, well, I own this residence, let's say, and I own it as a sole tenant, okay? Or you own it as husband and wife, as tenants by the entireties, and we want to, or I want to have a life estate in that property, and after my death, it's going to go automatically to my children or other remainder beneficiaries. So what this means is you shift it from sole tenancy to you have a life estate in the property, and you're either going to reserve a power to sell the property, so it's a life estate deed with power, or you're going to give up the power to sell the property, and that would be a Medicaid type planning technique. If you give away the power to sell the property for Medicaid purposes, you've actually given the property away. But let's pretend that you reserve the power to sell. All you're doing is moving it to a life estate. Your ownership interest in the property remains the same. if you pass away, the property will go to your children or other beneficiaries without probate and still get a step up in the cost basis. So that is a life estate deed, and I hope that's helpful. That's a probate avoidance device.
Hey, thanks very much.
You're welcome, Jeff. All right, thank you, everybody. And now we're going to continue. What is a qualified beneficiary? Well, under the Uniform Trust Code, there is a concept called the qualified beneficiary. Maryland adopted certain aspects of the Uniform Trust Code under the Maryland Trust Act. So just know that it's no longer the case that if someone is a beneficiary of a trust that they are in the dark. There is no such thing as a quiet trust in Maryland. Now, there are quiet trusts in other states such as Delaware, but in Maryland, if we pass away and we have a trust, the beneficiaries are entitled to notice and information. And you'll see some of these notice requirements. Now, when I first started this discussion today, you'll notice I talked about trustee fiduciary duty. And this is one of the things that can really creep up on you. If you're not aware of this and you're serving as a trustee, you could be at risk of not having notified qualified beneficiaries, and now you could actually be in violation of the terms and provisions of the law and trust, and you could have breached your fiduciary duty and be removed as a trustee. So what could be more painful or embarrassing? We want to make sure that we're giving notices to qualified beneficiaries and that whoever you appoint as a trustee understands these duties. Qualified beneficiaries are entitled to information. Now, you're going to hear people say that there are ways around this, but I do not believe that is the case. They are entitled to all information, for better or for worse, and generally speaking, this is a good thing. So if you need a quiet trust, we need to look to other jurisdictions, and that brings up another subject, which I won't digress into, is that we are living in a multi-jurisdictional practice area world today. So we are living in a world where more and more and more, we are in a multi-jurisdictional environment. Now, when you select a trustee or you are a trustee, there's going to be financial investments. Remember, we talked about establishing the proper allocations and so forth. So you're going to need to work with brokerage firms and financial advisors, and many of those financial advisor friends of Elville and Associates may be on this call today. But we're going to be establishing ways of paying bills, how to deal with debit cards and checkbooks, how to make sure on the death of someone that assets are stepped up, the appropriate assets are stepped up on the books and records. If there are multiple trustees, how does the broker-dealer deal with this? And making sure that if you are a trustee or your trustee understands that when they are administering a revocable trust, let's say, a revocable trust which has become irrevocable at the grantor's death, now that revocable trust has to be administered and accounted for and then distributed to the beneficiaries. Well, what if there are stocks or brokerage assets that should be maybe or are directed to be distributed in kind? So they are not necessarily to be sold, even though 90% of the time you're going to sell the assets. Why? You're going to sell the assets because you're going to protect against the downside, because what if the market goes down? Even though we're not in that kind of environment right now, your trustee or you as trustee, you have a fiduciary duty to protect what? The trust assets. You do not have an obligation, in my opinion, to make money for the trust after the death of a grantor. You have an obligation to protect the assets. So there are maybe reasonable middle grounds on that idea, but the idea is here, you need to work with your financial advisors and the brokerage firms after you are in possession and managing the assets as trustee. This is where I got a little bit ahead of myself here, and now we are establishing and we are managing a trust portfolio. We need to understand, are we to be investing under the prudent investor rule, which is generally the yes, the answer is yes. Are we dealing with a trust where there are some concentrated assets? Well, we have to be very careful there. All right, now I've been talking and too much in the first person. We really want to think in terms now of your trustee, the trustee that you have installed, okay? Is this person the person who's going to take all these things under consideration? More and more, I'm going to take a little digression, more and more, as we talked about this week in one of the webinars we did, I'm seeing clients become more and more concerned about getting their planning done sooner than later, making sure the planning is done correctly, which is a very good sign, but also making sure that the plan is actually going to work the way it's supposed to. And I think that that is really the question that we're asking today. How do we appoint the proper trustees, or how do we as trustees make sure that the plan is actually going to work the way it's supposed to? And so I just wanted to reframe that as we get into the weeds here with the various aspects of all things relating to trust. Is it going to work the way we want it to work? Is the trustee going to carry this out? So there's lots of bullet points, there's lots of legal technical, but the truth is, does our trustee have the wherewithal and the commitment to carry this thing out the way it's supposed to be? I have seen a couple of trustees recently that are just unbelievable in their commitment to making sure the trust works, and that's what we're looking for. So I brought that up very timely, because when we look at these concentric circles, what we're really talking about here is trustee at a very high level. Now, Jeff, I don't know why we don't have a picture of a perfect person here. Maybe there is no such thing as a perfect person, but these are the things we want to aspire to, okay? If we are the trustee of a trust, let's start in the lower left-hand corner. We want to be accountable, keep accurate records. How many of you know someone who has served as a trustee and they don't keep good records? How many of us in general don't keep good records? Well, now that's just not going to work with being a trustee. Keeping the beneficiaries informed. If the beneficiary asks questions, we have a fiduciary duty, generally speaking, to make sure that they get answers, that they get information. The trustee has to comply with the statutory duties we just talked about. Let's move over to the right-hand side. Financial investments. Are they hiring professionals? Your trustee cannot do it themselves unless they are an investment professional, and very few of us are. Hire professionals. That is the trustee's fiduciary duty. Hire tax advisors and tax preparers. Don't do it yourself. Don't try to cut corners. That's not fiduciary responsibility. Hire professionals. Now let's go to the top concentric circle. If this is a trust where there are at-risk beneficiaries or special needs beneficiaries, the trustee needs to have a working knowledge of public benefits or quasi-public benefits. And this is an area that can get very ambiguous, okay? One of the big problems with trustees for special needs trusts is they don't understand the public benefit world, and they don't understand exactly what kind of benefits the beneficiary is getting. Advocacy, promoting well-being and a high quality of life, this comes into play with some beneficiaries. I want you to take all this consideration as you think about trustees. So why is this so important? Well, trust can now last forever. Under the Old English law, trusts could only last so long. There was a big initiative in 2021, even though the rule against perpetuities, meaning the Old English law that said trust can only last a certain period of time, that rule has been abolished in almost all states. But there was an initiative in 2021 by certain members of Congress to limit the amount of time trust can last. But that initiative, even though it was very strong, did not prevail. So trusts can last pretty much forever, especially if you want them to last forever. And forever is a long time. So we want to make sure that we have trustee selection, successor trustees, which we're going to talk about, and good flexibility inside that trust, which we're going to talk about here in the last bullet point. Trusts are portable. We're talking about multi-jurisdictional practice. Trust can actually be changed as to state law and situs, the location of a trust. States are in competition for trusts. Delaware, South Dakota, Alaska, Nevada, Wyoming, even Tennessee is an asset protection state. You can accomplish certain things in various jurisdictions because of their statutes. So We want to have trustees that have an open mind to taking advice from professionals because of the changing world. Let's get down to something more fundamental. Your beneficiaries or the trust beneficiaries can be living in different areas, different places of the country. I speak with clients every week whose children live all over the country. So we don't know for sure that our beneficiaries by any means are going to be living in and die in Maryland. They may be living in a different domicile. Trustees have options. We don't want to forget that. We've done our due diligence. We've created trustee selection, but now our trustees say, sorry, I don't want to serve. The gentleman who posed the wonderful question just a moment ago, whose son does not want to serve. That was a very honest question, and it helps us a great deal because it illustrates that all we can do is do our very best, build in flexibility, as the last bullet point says here, for changing circumstances. There are ways of doing that, and to continue to update over the years, right? Because if we continue to update, we have a higher and higher chance that it's actually going to work right because of people's changing circumstances. A good example of this would be, I have served in many different advisory roles, and of course, many clients, and I've seen situations where clients were very devoted to a certain trustee situation, or even many corporate trustees that they were very devoted to in their planning. And lo and behold, when the person passed away, and this is a bit worrisome, so I don't want to worry you unnecessarily, but I do want to give you a perspective on this. The corporate trustee or the individual trustees refused to serve. This is not so uncommon. So we need to understand this, and we need to build in flexibility. We do the best we can, and that's all you can do. Decanting is a process of being able to change a trust substantially, or actually change a trust to a new trust. Maryland now has a new decanting law that's about 2 years old. It's a great law. We finally caught up to the rest of the country that has, many states have decanting. We need trustees who understand the multi-jurisdictional and the fact that in the last 20 years, especially the last 10 or 11 years, the world of estate planning and trust has evolved greatly into a whole different world of flexibility. We have to have trustees that understand that. So the trustee selection process for you could be very simple. You have a mental checklist, children, siblings, other relatives. But there are certain issues to be addressed. And some of these issues are very counterintuitive. As we think about selecting trustees, interested persons such as closer family members, the IRS code defines who is an interested person and who is an independent person. Or it could be an independent trustee, an arm's length friend of yours, or another person who's arm's length, like a lawyer or a CPA or other professional, versus a corporate fiduciary. And there are various tax ramifications and various asset protection, creditor protection ramifications in how these things are structured. So some of this is counterintuitive, but we could discuss this in a more intimate setting. Now, trustee selection is best done in person in the counseling sessions and in the process of review and building an estate plan or revisiting an old estate plan. But maybe we are well beyond that. Maybe the trust is already established. Maybe there is an old trust. Maybe there are conflicts, okay? Maybe there are changes in the law that have so much changed the ramifications of what could happen that the current trustees are not appropriate. Maybe they should be replaced. Maybe they don't want to serve. These are just many reasons why up front it's so important to do the best we can. But if we are down the road later, the trustee selection process might become more challenging. But there are flexibility measures available that weren't in existence 20 years ago that can help us with this. Trust protectors, for example, have been around in the law for quite some time. Maryland has had trust protector laws, or what we call trust advisor laws, since 2014. And trust protectors are one of the baseline tools to be able to change trustees if a trustee no longer wishes to serve, needs to be removed, breached their fiduciary duty and is no longer appropriate or has died. A trust protector can appoint a new trustee or remove a different trustee. So these are some of the considerations. Now, we talked about independent versus interested trustees. There are different standards of distribution. Health, education, maintenance, and support, which would be a standard, let's say, for an interested trustee versus a completely different standard for an independent trustee. But beyond that, and the asset protection ramifications that have to do with that and other ramifications, these types of trustees have different points of view, different resource considerations that they have, other practical considerations about filing tax returns, different levels of oversight, and all of it depends on the grantor's objectives and their goals. But again, we could be in a situation where we are down the road after a grantor's death dealing with an irrevocable trust or an irrevocable trust during life that needs to be addressed. I mentioned the trust protector. So what is the trust protector's role? A trust protector is just one of many special fiduciaries these days. This was something that started in some of the asset protection states way back when in the early 2000s. Wyoming, Nevada, Alaska, South Dakota, many of the asset protection states, Delaware. Maryland, again, adopted trust advisors in 2014, which in essence is a trust protector. And basically a trust protector, their powers are the power of amendment, and they also have the power to remove and replace trustees. This is a little bit of a difficult thing to get our minds around for some people, but it generally provides the first layer of flexibility. Other trust protector powers can be added, and this is beyond the scope of the discussion today. But a good thing to take away is a trust protector is not required, but a trust protector adds flexibility and gives us better flexibility about how to think about not only appointing trustees, but successor trustees down the road. Now, in a will, we have different types of trusts that can be established. So I'm going way back now to the fundamentals. We're going back to the fundamentals again. A will is a testamentary instrument. What happens at death? So if someone dies and they're married, they can create what we would call a family or bypass trust, or they could create a marital trust, or they could create trusts for young beneficiaries, or they could have a trust that lasts forever, one of those bloodline trusts. So we call this just the various roles of a trustee under a will. So there are various roles. Similarly, we have various roles for revocable trusts. And remember, a revocable living trust is just a substitute for a will. So we could have the same situation. Someone dies, they've left a non-marital bypass trust, or a marital trust, or a trust for young beneficiaries, or an irrevocable spendthrift trust that's meant to last forever for the benefit of that person, okay? That's very similar to what I just said, trusts established under wills. But look at the top bullet point. Because this is a revocable trust, it is a lifetime trust as well. So a successor trustee is going to step into your shoes if you have a living trust. They're going to step into your shoes, pay your bills, take care of you, take care of any person who's dependent on you, and you're still living. What does that sound like? That's similar to a financial power of attorney agent stepping into your shoes. So the revocable trust has the same death trusts that can be created, but it also is a living trust. These are the ways to think about the roles of a trustee in these basic trusts. As we start to wrap up, we might consider a corporate trustee based on their experience, asset management. I was talking to a very important client yesterday. We were discussing the use of a corporate trustee that is a broker-dealer that has a trust company, a very well-known trust company. So there could be advantages there. They're reliable. They've been around a long time. They have resources, peace of mind. They file the tax return every year for the trust. They have experience and they're going to manage the assets. And what you may find if you're interested in thinking about corporate trustees is oftentimes today, these trustee fees are being driven down due to competition. So it's worth thinking about. A corporate trustee is an independent trustee and may very well provide superior asset protection versus an independent trustee. But corporate trustees are independent. Individual trustees are independent. Not everybody is going to want a corporate trustee, but it is a good thing to know about and to think about. Why are we concerned about, quote, successor trustee risk? Well, we're all getting older. I hate to say it, but we are. We're all getting older, and age and experience matters. But what if we pass away? And by the way, people can be trustees today at much older ages than in the past when I was a young lawyer and we thought so. People were getting old at such a young age. But now it's really true that people are living a long time. So your trustee is not necessarily old when you think they're old. Age and experience do matter, but when they can no longer serve because of health or other issues, now we have to be concerned about this. How is this transition going to occur? Remember, most trusts do not require a bond. So your successor trustee, you have to trust them. This is a obvious thing, right? But you are placing a private administration of a trust into the hands of someone, and they are usually not required to post bond. Bonds are very expensive, so most of the time you are going to say, or grantors are going to say, no bond is required. It's something to think about. Other life changes, they become divorced, they have creditors, there's an unforeseen bankruptcy. Maybe that successor trustee that took over is disconnected with the needs of the beneficiary. I would strongly encourage you, if you have special concerns about beneficiaries, put that in the form of a letter of wishes. If it's a special needs or chronically ill person, put that in the form of a memorandum of intent. Put a binder together about someone, about how to take care of them and take care of their needs if they have special needs. What if, on the flip side, we have a demanding beneficiary? What if we have a beneficiary whose demands are so strong, who is so difficult to deal with, and this does occur, that it's almost impossible to administer the trust correctly? Your trustee could resign and say, I'm not going to do this. So just remember, there is risk. One of the risks is my trustee willing? Do they have the fortitude? Do they have the perseverance? Also remember, trustees are entitled to compensation. We have some new laws now that are basically, I guess, setting forth that reasonable compensation is broadly acceptable now. And we have to ask ourselves, what is reasonable compensation versus statutory compensation? So we just have to think about these things as we build successor trustees. Have we built in flexibility for all these changing circumstances? And have we taken into consideration that these people have to be willing to accept this role, and you have to have confidence that they're going to carry it out at a high level? It's a big task, it's a big thing, and I know some of you have acted in fiduciary roles already in your lives. At Elville & Associates, we have Waypoint Fiduciary Services, which is our branding of basically our trustee services. We are willing to evaluate situations to be trustee. We serve oftentimes as trust protectors as well as trustees in some cases, not at the same time, but in different types of cases or situations. We also advise trustees, and that's kind of an extension of what we're talking about here today. We will help families, trustees, administer trusts during life, if it's a lifetime irrevocable trust, or trusts at death that are meant to last forever or shorter times. We are here to help with those types of fiduciary support services. As we wrap up on time, I just want to thank everybody, and we're going to set aside a few minutes here for questions if anybody has any. Set an appointment with us, and if you have questions about how do I structure trustees, what are the concerns I should have in my particular situation, just like this wonderful gentleman who asked the question here just a few minutes ago, we're here to help you answer questions, help you form an advisory team, help you understand what trustee relationships may be available to you, including through your own broker-dealer relationships. There may be trustees right around you that you're not familiar with or aware of that could be good trustees. We want to answer your questions, and there's nothing to fear when you come talk to us. There is an attorney-client relationship that is very, very significant, so everything is confidential. So Jeff, I'm going to turn it back over to you, and I guess what I'll say lastly, remember, all planning is goal-driven. Take the time to think, and when you take the time to think in partnership, we will get to where we need to go. And I'll turn it back to you, Jeff. Thank you to everyone, and have a wonderful weekend.
Steve, thanks so very much. Having you guide us through that presentation, a very important topic. Really appreciate it today. Let's check for some final questions. We do have a couple here, and now's the perfect time to get those last questions in, Steve, and then we'll wrap up. Steve, a question that we've never had before, I don't think. How much influence does a trust protector have versus a corporate trustee?
Thank you for that wonderful question, and I'm going to try to give us a reasonable, reasonably considered answer when it's a very broad topic. If I gather anything from what I think you're asking, I will say that we have more concerns now than ever about the role of the trust protector, because I think we as a whole, as a society, are starting to see so much rapid change that people are more aware of what powers a trust protector has to deal with change. So I think people are scrutinizing the role of a trust protector much more than ever. So remember, a trust protector, and I want to make sure I'm answering the question in the way that you might be asking it. Remember that a trust protector is not in charge of paying bills. A trust protector has no access to the money. A trust protector is a special fiduciary who has a limited amount of powers to put forth the intention of the grantor. So I know there's a lot of interpretations that go on about a trust protector. I have had some clients recently who are extremely concerned about the trust protector's powers and whether they have more power than the trustee, which in many cases could possibly be true. Corporate trustees, remember, are just corporate entities that will administer a trust and manage money at the same time in most cases. They have control over the investments. They have control over the distributions to beneficiaries. Trust protectors, if given the appointment, have the power to remove and replace corporate trustees. Trust protector power is usually the power to remove and replace trustees in a fiduciary capacity in Maryland, and also the power to amend the trust administratively. Now, there are other trust protector powers that can be given, but those are the two basic powers. So remember, if I'm helping at all in this answer, a trust protector is a special fiduciary that has limited powers, even though those powers could be very significant, but they have to act in a fiduciary capacity to carry out the intentions of the grantor. They cannot act arbitrarily or capriciously, okay? A trustee, or especially a corporate trustee, has fiduciary responsibility to carry out the duties of a trustee, whereas a trust protector is a flexibility mechanism for the grantor to give the grantor ability to deal with a corporate trustee who, let's say, doesn't want to serve anymore, which I've seen, or a corporate trustee that's not the appropriate one for the beneficiary. So these are two different relationships, and I hope I've been able to paint that picture for you.
Thank you. We have a multi-pronged question here. I think you alluded to some of this. I'm going to go ahead and ask it though. Who ideally serves as a trust protector? What qualifications do they have, and how are trustee fees calculated?
Well, thank you. So a trust protector at this point in time, to my knowledge, is not going to be a corporate entity. I don't know of any corporate entities that will serve as a trust protector. Trust protectors are going to generally be individuals, and this usually and should be, with some exceptions or some trends, I will say, this is going to be an independent person. So this is going to be a friend of yours or it's going to be an attorney or a CPA or an independent arm's length person. Because remember, the trust protector is supposed to be acting without a conflict of interest and to be able to carry out their duties in that way. There are circumstances, especially in the world of special needs planning, where a trust protector may not be an independent person, even though theoretically they should be, and that family member could end up being the trust protector / advocate. So that is usually how a trust protector is thought about. And one of the challenges is to think about who should be the trust protector. The other layer is sometimes we don't appoint a trust protector per se. We appoint someone who will appoint a trust protector in the future if a trust protector is ever needed. So sometimes we do it that way, and that's a little bit less pressure. So you're going to decide, do I want to appoint a surrogate who will appoint a trust protector in the future, or am I going to go ahead and appoint my trust protector candidates now? The last question is, every corporate fiduciary has a fee schedule. So that's how fees are calculated. So your corporate trustee, for example, will have a fee schedule. Elville and Associates, for example, it's Waypoint Fiduciary Services. We have a fee schedule filed with the Secretary of State. So that's how fees are calculated generally. If the fees are not calculated according to a fee schedule, that is a matter of reasonable compensation and so forth. So the trustee fee issue is a little bit of a separate discussion, but it's a great topic for you to have brought up.
Well, thanks. Another one here. What is the difference between the services that Waypoint Fiduciary Services can provide versus a corporate trustee? There's also another question that just came through about competition regarding corporate trustee fees, and if you can elaborate on that briefly.
Sure. Well, thank you for that. So Waypoint Fiduciary Services is basically our trade name, our brand. So when we serve as trustee of a trust, let's say an attorney is serving as a trustee, remember that we are not a trust company. We are individual trustees, such as, let's say, I was serving as a trustee. So Waypoint Fiduciary Services is basically just an encapsulation of we provide trustee services. Now, what happens is when we serve as trustee, the difference between us and a corporate trustee is we will hire a financial advisory firm to show or to serve as a fiduciary so that we can properly invest the asset. So if we are serving, we are going to make sure the tax returns are filed. We're going to make sure that the financial advisory team that we are hiring are fiduciaries, and they are giving us an investment policy statement that they are investing on a fiduciary platform. So we are in those kinds of relationships as trustees. The corporate trustee is going to be the kind of entity usually that is going to have trustee services, and they are going to have the assets under management at the same time. Now, the last question there about competition is, this is just my experience, and I can only speak from my own experience as counseling clients for all these years. We have gone from a situation where when I was a much younger lawyer, there was a lot of speculation about corporate trustees not being desirable. Well, I have found in advanced estate planning over the years that that's really not the case. I think corporate trustees many times are excellent choices for certain people. They're not appropriate for everybody. And what I've noticed, back to the issue of competition, is that there are different relationships, right? There are more retail type relationships with corporate trustees, and there are more what I would call self-directed or discounted relationships. And it's the discounted relationships that I'm really talking about, where brokerage firms or your financial advisors, let's say, are vying for control of the assets under management long-term in the future. And if you were the kind of person that said, well, I want trustee services and I want this particular financial advisory firm to be the advisors in the future to the future trusts, or to serve my trustees, or to be my trustee, I should say. Now, under that corporate relationship, you can have your assets under management with the same financial advisory firm per se, depending on what their services are, and the prices are being driven down. Okay, so when you are thinking about trustees, this is part of the discussion to talk about how prices are being driven down by the fact that corporate trustees, meaning broker dealers, are going to want to keep your assets under management, and that's why that competition is so fierce to drive down the fees.
Okay, thank you. Let's do a couple more real briefly, and then we'll end on time. Can you comment about nonprofit disability trusts as trustees? Can they serve as a co-trustee with a family member?
That's a great question. I am going to just try to generally answer. The nonprofit trustees that are in the state of Maryland and locally, they all have good reputations, some more than others, and I think they do a fine job. And one of those, at least, has a philanthropic mission that's pretty impressive. And I know many of our clients that have loved ones with disabilities are looking to these kinds of trustees to have certainty, okay? And they feel that they have the professional ability to deal with that particular kind of situation. And some of these are also, of course, managing nonprofit funds for what is called D4C trusts. 42 USC 1396P D4C. These are pooled trusts, okay? And these trusts serve an important purpose in disability planning. So I don't have any opinion one way or another about these, except that they serve an important purpose. They sometimes will keep costs down, especially for people who are needing those pooled trusts. They don't have to go through the cost of establishing a trust with a lawyer. But there are circumstances where those kinds of pooled trusts or nonprofit trustees are not going to be appropriate for people who are, let's say, doing more conventional estate planning for special needs. And there are exceptions for everything, but some clients are not going to be, that kind of relationship is not going to be appropriate, and for some it will be.
Okay. And our last question, does a grantor trust function after the grantor's death? Is it worth buying a property outside of Maryland in order to have a tax avoidance of a trust at the point of death? So we'll start with that.
Well, thank you. I don't know if I'm going to be able to answer that last part of the last question, but I will say that a grantor trust is generally not going to survive after your death, because after your death, it's going to have to be a non-grantor trust, even though you took advantage of the grantor trust aspects of that trust during your life, if I'm understanding your question. When we die, those trusts that were grantor trusts are now going to have to be taxed because the grantor is no longer living. It's going to be taxed as a non-grantor trust in general and have to file its own 1041 tax return. And we have to start dealing with the issue of distributable net income, managing the trust taxation, managing the income that goes out to beneficiaries and so forth. And in special needs planning, that has its own aspects as well.
Steve, thanks very much. And,
thank you, Jeff, very much, and for everybody's participation.
Yeah, as always, I'll send the slides back out again along with the recording after it's available. Check out our YouTube channel for all of our presentations over the years. Upcoming events, we have our client event next Saturday. We're really excited about it. Registration is closed, but if you want to attend, I will sneak you in the back door. Just give me a call. We'll make it happen. We're also going back to Howard County Public Library on Friday the 24th, talking about estate and special needs planning and how they intersect. We have a new presentation called Estate Planning is About Love on November 12th with Steve, and I'll be talking more about our client care program throughout the years. So busy schedule ahead for everybody, including our webinar series, and hope to see you again soon. Steve, thanks again. Thanks to our attendees.
Thank you, Jeff. Thanks, everyone.